Good morning. I'm sorry to have kept you waiting. Is everybody present?
Yes.
Everybody present who needs to be present?
Yes, Your Honor.
Could you read the usual form of words then? Thank you very much.
Certainly. The hearings in the matter of CFI 53/2018 before Justice Sir Jeremy Cooke and is being held by way of video conference. Any orders or directions made after or during the course of this hearing will be issued by the registry in Dubai on the judge's instructions. The applicant is represented by Simmons and Simmons LLP, and the lead counsel is Robert Amy of South Square. Thank you very much.
Yes, Mr. Amy.
Your Honour, I appear on behalf of the joint liquidators of Abraaj Capital Limited. Can I confirm whether you've received my skeleton arguments and if you've had an opportunity to read it?
Yes, both.
I'm grateful, Your Honour. In that case, I can hopefully be quite brief in submissions, although because this is a slightly unusual matter, I probably ought to explain things properly. As I say in my skeleton argument, this is an application by the liquidators to the court to fix their remuneration. I propose first to give a brief background as to how we got here, then to set out the applicable principles to an application like this, and then apply those to the facts of this case.
Well, you can take it that I'm fairly familiar with Abraaj and its history. I've had some dealings in the past. So I'm more interested really in, so to speak, the technical side of it in the context of fixing remuneration. I've read what you've said in your skeleton, but if you can take me through the provisions, that would help. As I understand it, and you'll put me right if I'm wrong about this, there's a discretion in the court as to the mode of assessment. And even if one looks at it on a time basis, the court, quote, takes account of, rather than necessarily fixing fees in the way that the court might when looking at, for example, solicitors' fees in litigation. But some help on the principles that fall to be applied would be valuable. Thank you.
Indeed, Your Honour. In that case, I'll go straight to the part of my skeleton argument where I address this point, and I deal with the relevant rules at paragraph 13 onwards of my skeleton argument.
Yes.
First of all, I address the position for provisional liquidators, because, of course, part of the period for which we seek approval of remuneration is the PL periods. Yes. And I turn first to Rule 54.112 of the DIFC Court Rules, which sets out essentially 5 matters to which the court will have regard when fixing the remuneration of a provisional liquidator.
Yes.
And if I can simply go through each of those and explain how they're relevant to the present case. The first point is the time properly given attending to the company's affairs. Well, of course, I'll show you on shortly the timesheets, the very detailed timesheets that have been prepared by the liquidators and their staff. Secondly, the complexity or otherwise of the case. If Your Honour is familiar with the Abraaj Group liquidation, you'll know how complicated it is. And of course, it does merit a team of the calibre that the joint liquidators have employed to work on the case.
Yes, I might just need some assistance with the potential claims that may fall to be made. You can take it that, although not for a while, I read the DFSA's reports, so I'm familiar with the sort of general background, but I don't know what has actually happened in the context of what claims have been begun and who against, and so on and so forth. And that seems to be a material factor because of the potential recovery that may be made. And indeed, I think the form of order that you're asking me to make.
In that case, I'll just address that claim. It's been referred to in the evidence as the ACLD claim.
Yes.
The combined quantum of that claim is thought to be at least $500 million. That's at paragraph 15 of the fourth witness statement.
Yes.
The defendants have submitted to the court's jurisdiction, although that claim is currently stayed, I understand, while linked proceedings, while a jurisdictional issue in relation to potentially linked proceedings is addressed.
But do I take it that the defendants are those who used to run the show, so to speak?
I don't think the ACLD claim is against those who used to run the show. I believe that one is a claim against former auditors. I'll just...
Yes. I'm familiar with that. Yes.
Yes, I think that is right. I think that's the auditor claim, that one. I must confess, Your Honour, I'm not actually instructed on that claim itself, but I understand that to be the auditor claim.
Yes.
And you will have seen, Your Honour, in the same part of this statement, what is said, I think, at paragraph 21, is that litigation costs in that litigation will be paid from recoveries, or if there are no recoveries, from remaining assets. And there's a litigation funding agreement in place for that, which will ensure essentially that it's a risk-free endeavour from the estate's point of view, from the company's point of view.
Yes, it's litigation funding rather than a CFA, is it?
I will just double check that, because it's a because of course there's more than one claimant. It's a slightly complicated arrangement, but I do have.
I tell you what I went through my mind, so that you can deal with the point, is that the fixed remuneration at this stage could be done on a basis which allows for further remuneration, depending on how the recoveries work out. And so I'm quite interested to know, when you talk about no exposure at all to this company in the context of litigation, how that works.
Well, I can give some detail in relation to that. For a start, there's a litigation funding agreement with a separate external funder.
Yeah.
Which essentially covers, I understand it's 25% of the solicitor's firm budget and 50% of counsel's fees, and then the rest of that is covered by a CFA.
Right. Okay. And then there's some after the event insurance as well.
There is, yes, and I understand it's essentially another group entity. The parent, I think, is the policy holder, but that parent then has an obligation to indemnify the company in respect of any adverse costs liability.
Yes, and for practical purposes.
I'm sorry, you cut out there.
Actually, the way in which it operates. For practical purposes, one is treating the group as a whole, because that's the way it actually operated, without any real distinction between any of the entities within it.
Yes.
Yes. Okay. Very good.
So the overall sort of commercial consequence of those arrangements is that the company is not liable for any fees or costs above the funded or insured amounts in the event that the claim is unsuccessful. Equally, if the claim is successful, the company is not liable for any costs over an amount, over and above the amount of damages it receives. So the company will be no worse off as a result of the pursuit of this litigation.
Right. Well, that's what I needed to be clear about. Yeah.
I think also addressed in the evidence at paragraph yes, it's paragraph 33. It's intended that for the time being, even though the liquidators are seeking approval for the full amount, they're only intending to draw the sum of around $515,000 odd, which relates to general litigation matters. And when it comes to general liquidation matters, and when it comes to the additional costs of litigation, they're not currently looking to draw that until the outcome of the litigation is known.
Yes. Well, that was the point that I was directing you towards, as to whether, in fact, therefore, there is room for simply making an order at this stage in relation to the figure that they're planning to draw, and waiting to see how the litigation works out before deciding what would be an appropriate figure.
Your Honour, might I briefly take instructions on that point?
Yes, yes.
Your Honour, while I'm waiting for those instructing me to send me an email, I should probably make a couple of observations about Your Honour's proposal. One is the obvious one, of course, that if we have to come back to court again at a later stage, one obviously incurs the additional costs of doing that, and that's of course not just fees of attending the hearing, but of course all the fees involved in preparing witness statements and all the rest of it. The second point is that, of course, we have notified employees who are the only persons with an economic interest, we think, in this estate. Although we've had a couple of emails back from them commenting on the fact that they still haven't received a distribution that they were hoping to receive, nobody has suggested that they are unhappy with the liquidator's application for all of their remuneration to be fixed. So while I do see I do see the rationale behind Your Honour's proposal, I would draw your attention to those 2 points: the additional cost and the fact that creditors don't seem particularly concerned about it. I have just received instructions, though, to the effect that, of course, if Your Honour does require us to come back to court at a later stage for those additional costs, we will, of course, do that. We're in the court's hands.
But are you going to need to come back to the court in any event?
Well, not necessarily on this point, if we've already got the court's approval to draw that remuneration.
But what about future costs?
Well, to the extent there are any, yes, we would. I think it's currently.
I can't imagine that the liquidators are not going to incur further costs in the context of the litigation, regardless of the fact that legal costs may be covered. I mean, are you telling me the liquidators are making this as a once-for-all application, and that whatever happens in the future, they won't be coming back for more?
No, sorry, I wasn't suggesting that. What I was trying to say is, of course, that to the extent we have put in evidence of the costs that we're seeking, we would obviously incur some additional cost if we then sort of come back and have to sort of rehash all of that. But of course, I take your point, Your Honour, that if we're coming back anyway for some other costs, one can, to a certain extent, recycle this evidence.
The the only rehashing would be any additional costs that are incurred since the date of these that have been set out, and telling the court what the impact of the litigation would be, which one would have thought would redound to the liquidator's benefit if any significant recovery is made.
Indeed, Ron, I take the point, and I'm told that if Your Honour is of the view that it would be a good idea for us to come back at a later date for the litigation costs, we're content to do so.
Right. Okay.
Would it perhaps make sense if I made some brief remarks on the non-litigation costs?
Well, I've asked enough questions for the moment, Mr. Amy. So you take your own course as to the best way in which you think you want to approach this, and persuade me of what you say is the best course in the circumstances.
Well, Your Honour, perhaps I can pick up on the law where I left off at paragraph 14 of my skeleton argument, and that's where I turn to the DIFC insolvency regulations, and the way in which liquidators are to be remunerated. And at sub-rule 3, the rules say that it's for a liquidation committee or a creditors meeting to determine remuneration. And then at sub-rule 4, it is said that if remuneration is not fixed, then a sum equal to 5% of amounts realised plus 2.5% of amounts distributed is the default amount. Now, although I'm not seeking to apply those percentages in this case, I do say that they provide a useful guide to what the rules or the regulations typically think is appropriate. And then regulation 6.34.1 obviously applies for the courts, provides for the liquidator to apply to court for fixing of remuneration, which is of course what the liquidators are now doing. Now, by way of explanation as to why we've come to court and haven't resorted to a committee or a meeting of creditors, there is no liquidation committee. We've notified creditors that they are employees who we understand are not essentially motivated to form a committee or to take an active role. And the only two who have responded to our email haven't really said anything substantive on the application. And given that the joint liquidators don't consider it proportionate to try and get these people to form a committee when they don't seem particularly motivated in the first place. Now, as for the percentages which I outlined a moment ago from the insolvency regulations, the fourth witness statement explains why simply applying those default percentages would work an injustice. But as I say, they are a useful guide. First of all, assets and distributions, if one simply had regards to those properly so called, total fees would come out at $90,000. Yeah. But that would be a huge undervalue because, of course, it wouldn't take into account the deal done for the employee claims, which is worth about $10 million. Yeah. And now, if one treated that $10 million as a notional realisation, then total fees would come up to $840,000. Now, you'll immediately note, Your Honour, that is less than the general liquidation amount which is being sought, which is in the region of $515,000. So, if anything, by applying the hourly rates that the joint liquidators are suggesting, they're actually getting paid less than if they were doing it on a percentage basis according to the rules. For all those reasons, I submit that the fairest way to set remuneration is by reference to time properly given. Your Honour would have seen in the bundle that there is a detailed timesheet prepared in accordance with SIP 9, which would apply in the English court. Of course, there's no DIFC equivalent, but the liquidators consider that that's an appropriate format in which to set out what they are charging. And if one starts at electronic page 40 of the bundle, the internal pagination is B31. Yeah. The court will see that the fee earners have applied a 25% discount to their usual hourly rates.
Yes.
The next page is a sheet which shows where the various time costs fall in relation to general sort of broad tasks in the liquidation. And then overleaf begins a very long list, essentially a timesheet of what each of the fee earners has been doing over the course of this liquidation.
Yes.
Other points made in the evidence, of course, are that secretarial time is not charged separately. That's treated as an overhead and absorbed in fee earners' hourly rates. Except in exceptional circumstances, no one is charging more than 8 hours a day, even if they are actually working more than 8 hours a day. So for those reasons, the liquidators and their firm are charging considerably less on this matter than they might do if this was an ordinary commercial matter at which they were charging their full rates and charging for all of their time. For those reasons, and of course by comparison to the yardstick given by the percentages in the rules, I do submit that the amount sought by the joint liquidators in their bill is an appropriate amount in accordance with the regulations, and I invite the court to allow the full amount claimed in respect of general litigation matters. Now, there is one final matter. Your Honour asked about the cost of the ongoing litigation, and that's addressed in the fourth witness statement at paragraph 44. It's on electronic page 32. And the witness statement says that under DIFC insolvency law, there's no requirement for the liquidators to report to creditors on a regular basis. But if the court fixes the basis of remuneration by reference to time properly given, the liquidators intend to draw remuneration on a 6-monthly basis.
Yes.
So essentially, if the court today directs that it's appropriate for remuneration to be fixed by reference to time properly spent, the court can obviously approve costs that have already been incurred, and it's a matter of the court whether it wants to approve all of the costs that have been incurred or simply the non-litigation costs. But the proposal is that essentially if the court is content with remuneration on a time cost basis, that will be the basis on which the liquidators seek approval going forward.
Yes. I don't know what that says about confidence in the claims to be made, because if the claims to be made have the prospect of recovery of 500 million, you would expect liquidators to be interested in having their fees dealt with in a proportion of the recovery there, wouldn't you? The point I was putting to earlier was that if in reality you're going to come back to the court in any event for whatever future fees and on whatever basis you want to claim them, there's something to be said for giving an interim order, if I can put it that way, at this stage, and waiting to see how recoveries work out at the end of the day. May or may not work to the benefit of the liquidator, depending on the success of the claims, I suppose.
Yes, I do see the sense in that, Your Honour. And as I say, if that is the view the court takes, the liquidators are, of course, content to come back to court for approval for those sums. They are the court's own officers, and they'll do as Your Honour directs. I think it was largely the well, 2 points. First of all, once the liquidators have decided to apply for their remuneration on a time cost basis, I'm not sure it necessarily assists them if they come back at a later date and show that there have been sort of fabulously large recoveries, because if they're billing for their time, they're not necessarily going to get any extra if the recoveries are 500 million rather than, say, 50 million. So there's that point. I'm not sure it necessarily follows that they're better off.
Sorry to interrupt yet again, but is what you're telling me that as a matter of the court's powers, by reference to the regulations, the court has at this stage to opt for one basis of remuneration or the other, and the liquidators have elected to go for time cost basis rather than percentage of assets distributed basis.
I must confess, I haven't actually looked into that position in the rules. I'm not sure whether it's possible to change basis partway through under the DIFC insolvency regulations. I know certainly under the English rules, there was at one stage a debate as to whether you could have sort of a mix and match of bases. And I think the reforms to the latest English rules say that you can, but I think previously it maybe wasn't the case. I'd have to look closely at the DIFC rules to see what the position is.
Let me tell you, if I was to order an interim payment, for example, it wouldn't need to be expressed on the basis of either time cost or asset distribution percentage, would it?
No, it wouldn't. You could simply specify a figure, and the liquidators could come back at a later stage and seek.
You see, I tend to think that's the fairest thing all round, and I'll tell you how my mind's working. I think that it would make sense to make an order at this stage for an interim payment that took account of effectively the 10 million that has been achieved, whether or not it is technically an asset, which would give rise to a payment of, I think it's $840,000, is it?
I'm sorry, I didn't quite catch that. Is it the?
If, for example, I simply made an order for an interim payment without specifying the basis upon which it was made, therefore not requiring your client to make a once-for-all election, and I ordered in accordance with paragraph 41 of Soden 4 a figure of $840,000. I don't know what that is in pounds, on the basis of taking into account, so to speak, the 10 million that has effectively been recovered, if you can put it that way, even if it isn't technically an asset. It would simply be a way of assessing what's a reasonable interim payment without necessarily specifying the basis upon which the fees have been assessed. And then when the position is clearer as to what, if any, recoveries are going to be made in litigation, the liquidators can come back and decide on what basis they want to claim remuneration for the total figure they claim.
Yes, well, can I briefly take instructions on that?
Yeah, of course you can, but I say I don't know what the figure works out at in pounds. It's probably not very different from dollars just at present. But that would be more than the 515,000 that is being spoken of. So they're not going to be hugely out of pocket, but preserves all options for the future, both for the liquidators and for the court.
Yes, Ron, I'm told that if the court is willing to award $840,000 now, with liberty to apply as to the remaining costs associated with litigation, that would be a satisfactory outcome for the liquidators.
I thought they might think that. Very good. Well, that's what I propose to do. Would you like to think about how to draw up the order, which needs to be pretty clear that this is an interim payment only, and leaves it open both to the court and the liquidators to deal with future costs and indeed past costs, because this is a payment on account, without any commitment to the basis of the charge in accordance with the regulations.
Yes, Your Honour, I'll come up with a suitable form of words for that.
We need it. I think it needs to be spelt out in the order itself.
Yes.
That's what's happening. So it's clear to all and sundry. I would guess the matter will come back before me, unless it takes many, many, many years. In which case, I may be too old. Who knows? But I think that's the fairest way to deal with it. Are you happy to draft that and submit that for approval?
Yes, Your Honour, I'll draw something up and send it in.
Very good. You can take it that I've been through all the evidence and I've looked at the timesheets and so on and so forth. And broadly speaking, I can't see much wrong with the way in which the time costs have been assessed. It's just a question at the end of the day as to what the fairest thing to do is, both from the liquidator's point of view and from the point of view of the company itself, of course.
I'm grateful, Your Honour.
All right. Anything else that needs to be covered now?
No, I don't think so, Your Honour.
Very good. All right. Thank you. Well, you'll need to submit the draft to the court, who will then forward it to me, and we'll sort that out. You'll probably get an order after the weekend, I would guess.
Your Honour, there is one final point. It's, of course, the out-of-pocket disbursements, which is a very sort of small sum, but it's essentially travel costs.
Yeah. No, you can have those in addition.
I'm grateful.
Yeah, very good. All right. Well, if you wouldn't mind signing out and just leaving me with the court associate, that would be very helpful.
In that case, I'll do that now. Thank you.
Thank you very much.